What is a debt validation letter? How do you use it? How does it protect your rights? And should you bother using one at all? My name is Michael Wasylik. I'm one of the lawyers at Ricardo and Wasylik here in Florida, and together with my partner Jason Ricardo, I help people just like you overcome foreclosure and debt collection with dignity. Today I'm going to talk about what a debt validation letter is, how you can use it, and how you can use it to protect your rights, and when and how you need to send it, what it needs to contain, all of that great stuff. So before I launch into the nitty-gritty details about debt validation, I want to ask you to subscribe to the channel if you're new. Give it a try. Lots of information about debt collection and about your credit score as it relates to debt collection. Number two, if you watch this video and think it would be helpful to someone else, please consider sharing it with that person. And number three, if you have a question that I don't answer in this video about debt collection, drop in the comment section below. We do everything we can to answer every comment, either in the comment section or with a video answering the question. So please drop a comment if you've got a question that I haven't answered yet. So with that out of the way, let's talk about debt validation letters and what they are. So the right that you have to request validation of a debt comes out of the federal statute, the Fair Debt Collection Practices Act, and specifically it comes out of 15 U.S. Code 1692G, subsections A and B. And I'm not going to ask you to memorize that. I'm going to tell you what they say. Within 5 days from you receiving a communication from a debt collector, that debt collector is supposed to notify you of certain rights. Now, that first communication can be a phone call, it can be a letter, it can be online, text message, social media, anything like that. That first contact with you from that debt collector, that triggers their 5-day window to send you a letter that contains 5 important rights that you have. That notice that they're required to send you requires them to tell you, number one, the amount of the debt. How much do you owe? Number two, who do you owe the debt to? What's the name of the creditor? Number three, a statement that unless you dispute the validity of the debt, that they will assume it to be valid. Now, that's something that ties people up in knots. I'm going to talk about that in more detail in just a minute. Number four, they have to tell you that if you notify the debt collector in writing that you dispute the debt, that they will obtain verification of that debt. And what that verification is, we'll talk about in a minute. Notice that they use the word verification there, not validation. The statute uses both words, and so it's very important to understand that there is a little bit of a difference. We'll talk about that as we go through the whole statute. The fifth thing they have to tell you is that if the original creditor to whom the money was owed is different from the current creditor that the debt collector is now collecting for, they have to tell you the name and address of the original collector if you ask for it. So now that we've listed off that part of the statute, I want to make a note that if it sounds confusing to you, you're not alone. Federal judges don't even understand the statute very clearly, and they because it's not very well written. And federal courts have read the statute, tried to figure out what it means, what rights attach, and even the appellate courts at the federal level don't agree about what rights are supposed to be informed to you in that 5-day letter, that 1692G letter. So depending on where you are in the country, your courts may interpret the law differently than in some other parts of the country. So if it's a head scratcher for you, it's a head scratcher for me, it's a head scratcher for the courts. You're not alone, so don't feel bad. Now, given that this is very confusing about what's supposed to be in the letter, let's talk about what rights you have, what your response can be, and what options you have. So you have 3 options once you receive this letter, and you have one very important option if you never receive the letter. And I'm going to hit that right now because it's going to be the most important. If a debt collector is calling you and never sends you this 5-day letter, they violated the law. You have a right to sue. You have a right to vindicate yourself. You have a right to collect money from them. If you are in this situation that you're getting phone calls from a debt collector that's never sent you anything in the mail, then you may have a right to sue them. that's something we should talk about. Now, if you have that situation, stop the video, don't pass go, drop directly to the click to call link I'll put in the description. Click and call us if you're in Florida. If you're not, we'll try to hook you up with somebody in your region who is. But if you have gotten debt collection phone calls but not a letter, they've broken the law if they're a debt collector, and they may be in a point where they owe you money because they've broken the law. Now, that's if they never send you the letter. However, most debt collectors will send you this letter well in advance of any kind of communication. In fact, it's usually the first communication you get, even though there's a 5-day limit. If they call you first, they have to send a letter. This is usually the first communication most debt collectors will do, and they don't start calling until later, okay? But when you get that letter, a lot of people get bent out of shape about that language, about they'll assume the debt to be valid if you don't dispute it within 30 days. Now, your 3 options upon getting that letter and reading that language, most people assume that they have an obligation to respond, and if they don't, they're giving up their rights. That's not true. The failure to respond cannot be held against you. The refusal to respond cannot be held against you. You cannot give up the right to challenge the debt simply by refusing to respond to a 5-day notice, right? To the 1692G notice, where they say if you don't respond within 30 days, they'll assume it's valid. Well, they can assume all they want. You still have a right to challenge it whether you respond or not. So option number 1 is you can simply ignore it. Now, that's not always the best option. You should make sure that you know your legal rights before you choose to ignore it. There are good reasons why you might choose to ignore it. There are good reasons why you might choose to respond to it. That leads us to options 2 and 3. You can respond to the letter, and you can, in your response, dispute the validity or the amount or any portion of the debt. And number 2, that's option 2 is dispute. Option 3 is when you respond, you can also request verification. Remember, I use that word verification. And options 2 and 3 can be done together, and they should be done in writing, even though that part is not completely clear from the statute and from the letter that you might get. Your dispute should be in writing. Your verification request must be in writing, and we'll talk about why in just a second. So, if you choose to dispute the debt, it's very simple. Any basis you have to dispute the debt, any reasonable, valid basis, any good faith basis you have, if you don't recognize who the creditor is, if you don't believe the amount is accurate, if you don't think it's your debt, if you don't think they have a right to collect it for any reason, if you don't think you have an agreement with them, whatever the reason may be, you can say, and by the way, you don't need to say in your response what your dispute is. You can simply say, I dispute the validity of the debt, period. That's all you have to do. And that triggers your rights under the law, having disputed the debt in writing, because there's a second part of the statute, it's subsection B, which talks about your rights if you dispute. And I'm going to make sure that we talk about that before the end of the video. Now, that's the dispute. The next thing is you can request verification of the debt. Now, what is verification? This is another thing that the statute is very unclear on. This is another thing that federal courts don't all agree on what it means. And so the simple and most basic explanation is that verification of the debt is you asking for information that allows you to figure out whether it's your debt and figure out whether the amounts are correct. That's it. And there's no part of the law that defines what it is. The courts have interpreted this to mean that they have to give you some very, very basic minimal information. It's not a lot. There's not a high bar for this. And once they respond, a lot of people are like, well, they didn't give me enough information. There's nearly no way to say that they didn't give you the information you asked for as long as it meets that really, really low threshold for their compliance. So when you request verification, they will typically respond to you with an account statement. It might have a name and address. That's enough in the court's eyes to tell whether you're the right person, right? Now, they may have a mistaken identity problem. There may be all kinds of reasons why you're not the right person, but if they have your name and address, that's all they have to provide. Let's say they provide you with the name and address of somebody that's absolutely not you. If your name is John Smith and they've got a John Smith that lives someplace you've never lived, then you can make a legitimate argument that that's not me. That's a different John Smith. There's a confusion here. And therefore, they've given you enough information to tell whether you're the right person. If they come back with your name, your address, then it's fair to say they have identified you as the person. Now, you may have legitimate defenses against that debt. You may have reason to believe that, you may not be the right person who signed up for it, but they are currently identifying the person they're seeking to collect from. That's all they have to do for the identification part of it. Then they have to give you enough information to tell whether the amounts are valid. Now, that does not mean that they have to give you an exhaustive list of all charges and everything that's ever been done on the account. However, they do have to give you a reasonable accounting of what the number is that they're seeking, why they're seeking it. Again, they might give you a statement, they might give you multiple statements, and that is supposedly going to be enough for you to look at that statement and say, well, I know I never had a credit card for $10,000 because my credit limit was never over 2, and so therefore that can't be my debt. That's enough information for you to challenge the validity of the debt. And so they've met their bar for verification. Now, a lot of form letters out there for debt validation will tell you, ask for the sun, moon, and stars. Ask for every bit of documentation that you can. Now, you can ask for whatever you want, but they do not have an obligation to provide it to you. All they have to do is give you sufficient information for you to tell, are they looking for the right person and are they asking for the right amounts? Okay, so that's the very low bar that they have in order to meet the verification requirement. Now, what happens if they don't give you the verification? If they don't respond at all, they have violated the law. The failure to provide that information means that, let me just backtrack a little bit there. Until they give you that verification information, they're not allowed to collect from you anymore. They're not allowed to contact you asking for money. They're not allowed to call you on the phone asking for money. They're not allowed to file a lawsuit against you. They can't do any of that, any debt collection activity, until they provide you that bare minimum information that you're entitled to under the law. If they collect from you, if they file a lawsuit, if they call you or write you letters demanding money before they've given you that verification, that's when they've broken the law, and that's when you can sue them, and they will owe you money. Again, if you've had a situation like this where you've asked for verification, never got it, and they still collected from you, give us a call. If you're in Florida, we can talk to you about your case. If not, we can hopefully find someone else in your area who can help you with that claim. So if they provide no verification and collect the debt, they're breaking the law. Now, if they provide some documents, but you don't think it's enough, that's going to be a gray area. Most courts are going to give them the benefit of the doubt, but it may be that they give you so little that you can't reasonably tell whether or not you owe the money. That's something that may be a violation. We can help you investigate that, again, if you're in Florida, or if we can hook you up with a lawyer in your area. Now, the reason you will want to send a debt validation letter, what's called a debt validation letter, the reason you might want to send that letter is because when you do, you are notifying the debt collector that you dispute the debt. That requires them to do two things. Number one, they must first provide you that verification if you've requested it. So if you've told them you've disputed it and you want verification, They have to stop collections until they give you that verification. And then under subsection B of the statute, it says that if you have done this notification in writing within the 30 days after receiving the 5-day notice, after receiving this letter from the debt collector, they must, and I'm going to be reading from the statute here. So, they are required to cease collection activity until they until they give you the verification. And if they don't do that, if they don't stop, they are breaking the law. So that's the benefit of getting that validation letter in response to you receiving this notice. The other thing is, if you are disputing the debt, they are required to amend any credit reporting, any entry on your credit report, and they're recorded a note that you've disputed that. If they have reported it to your credit report, they have to report that you're disputing it, and they can't report it without telling the credit reporting agency that you're disputing it. So that's another right. And if they fail to do that, that's a separate violation of, believe it or not, the FDCPA, of the Fair Debt Collection Practices Act. So the reason you will want to send a validation letter, if you decide to send one, is because you want them to stop collection activity. You want them to give you some basic information about the debt in order to let you determine whether or not it's truly yours and whether the amounts are in dispute. So that's the reason you'd want to send that. Now, should you use a form letter? How should you send the letter? When should you send the letter? So when you send the letter, that's the easiest question. You have 30 days from the time you receive this notice. If you don't receive the notice, the time never starts running. They violated the law if they're contacting you without sending you the notice. Again, you can sue and put money in your pocket. If you do receive the notice, the 30-day window starts from there, from the time you actually get it in your hands. And then you would write within that 30-day period. What do you say in the letter? I always like to keep it simple. If you dispute, if you send a validation response, you say, number one, I dispute the debt. If you want to limit it to the amounts or the validity or whatever, just put that in. You don't have to be detailed in why or what. Just say, I dispute the debt. Please provide verification of the debt, period. That's all it has to say. And when you do that, that triggers all your rights. Now, if they fail to meet their obligations under the law, you have a right to sue. You have a right to collect money if they are violating the law, if they're a debt collector that is covered by that. The other reason you would want to write a debt validation letter is because eventually you might find yourself in court defending a credit card suit or defending a debt collection lawsuit on this account. And if you receive the letter that gives you these rights and you respond to it within 30 days saying, I dispute the debt, please give me verification, that is something that is establishing a record that you're disputing the debt. And that is something that's establishing a record that you don't recognize it or that you don't believe it's legitimate. And that letter may and likely will end up in front of the court. And that is something, judges like to see people who don't sleep on their rights. They like to see people who respond in a measured and timely way without giving up their rights. So if you write a polite but firm letter saying, I dispute the debt and I want verification, that is going to be shown to the judge. It's going to be shown, if you have a jury, it's going to be shown to the jury. So remember a couple things. Be polite. Don't be a jerk. If you're a jerk, then the judge isn't going to like you, the jury's not going to like you, and even if you have a legitimate case, they might not want to rule for you, because if you're a jerk, it just makes it harder, okay? It shouldn't be that way, but it is. If you're a jerk, you're gonna find it harder to win your cases. Be polite, be firm, be correct, and then that letter, when it gets in front of the court, will help you and it won't hurt you. So that's kind of the tips I have. Now, where should you send the letter to? The notice you get will tell you the address to send it to. I always recommend that when you send disputes in writing, you send them by certified mail return receipt. That means the green card and the whole 9 yards. It's like $5, right? And that $5 can save you a whole lot of heartache down the road. So make sure to pay to get the return receipt, the green card. Number 2, keep a copy of everything you send. If you send a letter saying, I dispute the debt and I want verification, and they never respond, if you didn't keep a copy of it, you have no way of enforcing your rights. You have no way of suing. So keep a copy of anything that you receive, or anything that you send rather, and everything you receive when you are disputing the debt. So send it certified mail return receipt, send it to the address that they tell you, send it within 30 days, keep a copy of everything. And if you do that, you are setting yourself up for success down the road. You are going to have a better chance of getting the leverage you need in order to resolve your debt collection case in your favor and avoiding the damage that a lot of people do to themselves. So I hope this was super helpful to you. If it was, again, subscribe, like the video if it's been helpful, share with somebody else who needs it, comment if you got a question below. I've got other videos I'm going to provide to you with other information relating to this topic. So if you want to learn more, go ahead and click on the videos that are going to appear on your screen right now. Thank you for watching, and I'll see you on the next one.